Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on a really tricky issue. I think it's an issue that a lot of my viewers, and myself included, struggle with. And it's the issue involving illegal aliens and firearm rights. Now, there really is two schools of thoughts. The one school of thought is hey, they clearly are not part of the people, therefore they're not protected by the Constitution, therefore they don't have gun rights. But then there's another theory that says, well, wait a second, I thought these were God-given inalienable rights that government cannot take away from any person. Are we saying that the Creator actually only gave those rights to those people born in the United States of America? Well, it appears that a court in Ohio has weighed in on it because the rulings have been all over the board on this issue, and they have come up with a very unique way of saying no. Illegal aliens do not have firearm rights. What is it? Well, we're going to explain that. So today, let's spend a few minutes and let's talk about maybe this is why illegal aliens don't have gun rights. Okay, we're going to talk about the very sticky little situation involving illegal aliens and firearms. Specifically today, we're going to be talking about the case of United States versus Serrano-Restrepo. It is filed in the United States District Court for the Southern District of Ohio. The case was decided by a Clinton-appointed judge. Yes, this is a challenge to 18 United States Code Section 922 G5A, which all of you know actually prohibits a person who is not an American citizen from possessing a firearm. Now, you may recall this video right here about an Obama-appointed judge in the case of Carbajal Flores, in which that judge found that the exact statute we're talking about today here was in fact unconstitutional as it was applied to that particular defendant in that case. But the court here has reached a much different conclusion. Now, not going to bore you with the facts, but let's just put it this way. The named defendant in this case had been in the United States for many years. And yes, he was here as an undocumented immigrant. He had an asylum claim going, but there was all sorts of procedural deficiencies with it. Now, during the time that Mr. Serrano-Restrepo was in the United States, he was a very productive member of society. He not only worked diligently, eventually was able to buy his own company, run his own company, and by all accounts, had done quite well for himself. He also, during that entire time, was never a United States citizen. However, that did not stop the defendant from going out and purchasing dozens and dozens of firearms. And as a matter of fact, according to the account here, he had a pretty nice collection. The problem is that every time Mr. Serrano-Restrepo filled out a Form 4473, well, he said that he was, in fact, an American citizen. Now, that is not what he is being prosecuted for in this case. What he's being prosecuted for is being an illegal alien in possession of those 100+ firearms that he did purchase. Now, this is an as-applied constitutional challenge. There are facial challenges and there are as-applied. Without getting too far down that rabbit hole, let me just try to give it to you in simple English. A facial challenge is where a plaintiff says there is no circumstances known to man anywhere on God's green earth in which this law could be constitutionally applied. Very lofty burden. An as-applied challenge is saying we're not saying that there is no way that this law could be applied constitutionally. What we are saying is to the facts of this particular case, and in this case being Mr. Serrano-Restrepo, the law as applied to him is unconstitutional, which was the exact same challenge that was issued in Carbajal Flores. Okay, question number one. Is an illegal alien even part of the people? Well, what do you think the United States government argued? The government does not suggest that the possession of a firearm is conduct outside the protections of the Second Amendment, but argues that Mr. Serrano-Restrepo himself is not protected because the people does not include unlawful immigrants. Mr. Serrano-Restrepo does not dispute that he is an alien, illegally or unlawfully in the United States, but he argues he is nonetheless included in the term the people and that his constitutional rights are being infringed. Now, as we mentioned in the intro to this video, the rulings from other courts trying to tackle this issue are all over the board. Thumbs up, thumbs down, and for various different reasons. Of course, what the defendant is arguing here is that he's been in the United States acting like a lawful citizen for a number of years, and therefore he is part of the people. And if the government's argument is wrong, what other rights is he deprived of? And if the government is actually correct in their argument, then how many rights does he have at all? As the court put it, relying on Heller, Mr. Serrano-Restrepo reasons that he is among the people who have the right to bear arms because he has been part of the national community and developed sufficient connections with the United States to be considered part of its community. As a result, he is guaranteed certain protections under the Constitution, and his lack of documentation does not support a per se exclusion from the people protected by the Bill of Rights. And that's an important ruling, because one of the points made by those people who said, listen, this is an inalienable God-given right is are you saying that this person has no right then to speak freely, that he has no right to worship whatever religion he chooses from? He has no right to be free from unreasonable government searches and seizures. He has no right to be free from self-incrimination or cruel and unusual punishment or any of the other protections outlined in the Bill of Rights. So, here's an opportunity for this court to add some real clarity to an issue that a lot of courts are struggling with. So what do? Oh, they completely avoid the issue altogether. It's a complete cop-out. They basically say, hey, we can decide this without having to answer the question. As the court put it, because the court can resolve Mr. Serrano-Restrepo's motion based on whether history and tradition supports the challenged regulation, the court declines to reach a definitive conclusion on whether Mr. Serrano-Restrepo is a member of the people, but will assume without deciding that he is for the purposes of the analysis below. And you're sitting there going, okay, so you think you can justify this on history. How can you do that? Well, here comes the punchline. That's right. Mr. Serrano-Restrepo, he got Rahimi'd. This is how the court did it. A challenge regulation is consistent with the nation's tradition of firearm regulation if it addresses the general societal problems that has persisted since the 18th century. But when a regulation addresses unprecedented societal concerns or dramatic technological changes, drawing historical analogies may require a more nuanced approach. There it is. The more nuanced approach. And I told you when Rahimi came out, we were going to get this language shoved down our throat. The court goes on to expand Rahimi in this way. Nuance is required because the Constitution must apply to circumstances beyond those the founders specifically anticipated. Thus, the court may look to relevantly similar regulations rather than distinctly similar regulations and engage in reasoning by analogy. Okay, now listen, you may be perfectly comfortable with the conclusion the court came to, but what I'm telling you is you might want to be a little uncomfortable with how they got there, because this line of reasoning can be used a lot of different ways then. Because of that, because of this more nuanced approach, you see, the court gets to make the following rulings. The possession of firearms by immigrants unlawfully presented in the United States was not a general societal problem in the founding era. Okay, so what history are you going to come up with then? Well, it's this. Oath-based restrictions provide a sufficient historical analog to show that Section 922, G5A, is congruent with historical firearms regulations. Yep, that's right. So it is the Catholics and the Native Americans and all the non-loyalists that are going to uphold this law according to this United States District Court in Ohio. The court specifically has ruled, at the time the Second Amendment was ratified in 1791, the government contends that the Second Amendment did not protect the right to bear arms of outsiders such as Native Americans, Catholics, and loyalists who refused to swear oaths of allegiance. These outsiders were disarmed because they were perceived as dangerous to public safety or social stability, and thus not trusted to possess firearms. And again, I want you to think about that line of reasoning, because if that line of reasoning were to continue to be perpetuated throughout the court system, do you realize there's no logical end to where they can take this? The court also ruled, when the right to bear arms made its way to the American colonies, so too did the prohibition on Catholics owning firearms unless they swore loyalty. These statutes reveal that there was a well-established tradition of prohibiting the possession of firearms by those who did not swear loyalty to their government or political community. Those who did not swear an oath were perceived as dangerous to the political community due to their divided loyalties. That's right. It's all about expressing where your loyalty lies. The court further stated, oath-based restrictions prevented firearms from ending up in the hands of those who had not demonstrated allegiance to this nation and might do the nation harm. These restrictions, although perhaps flawed, reflected an attempt to distinguish between those likely to comply with certain communal obligations and societal norms and those less likely to do so. And so for that reason, the court has said whether or not the defendant here is part of the people is completely irrelevant to the conclusion that we draw, because the court has ruled thus disarming unlawful immigrants like Mr. Serrano-Restrepo, who have not sworn allegiance to the United States, comports with this nation's history and tradition of firearm regulations. Mr. Serrano-Restrepo's as-applied challenge lacks merit. The swearing of an oath of allegiance occurs through the naturalization process, not through his asylum application or his years of living in the United States. Consequently, Section 922 G5A is not unconstitutional as applied to him. Okay, and like I say, many of you may be in complete agreement with the ruling itself, but I want you to pay careful attention to the very dangerous reasoning that was used to get the court to that conclusion. Okay, the case once again is the United States of America versus Carlos Serrano-Restrepo. We're going to link it all up down below so that you guys can geek out on it for yourself. Maybe you got some questions about this or anything else related to what's left of our Second Amendment rights. If you do, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, we'd love to hear about it. Click on that link right there and let us know. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.